Welcome to video 22 of this series on land and those interests annexed to land, and predominantly how you then arrive at your true inherent rights, which are before English common law and equity. I had spoke to the fact of going next into law of persons and law of things, but I thought it may be best to continue on our journey through the history which now have arrived us into the Statute of Uses, to which I gave some sort of referral back when I was speaking about Richard I and the first or the Cestui Act that was established. So maybe we can just do a quick overview again how we arrived at a use. Predominantly after the conquest of AD 1066 and William the Conqueror, we had merged the English common law of that time with that of the French Norman laws, which were Roman, and the predominant feature of the William the Conqueror was to create a militant style top-down function whereby he would be the supreme ruler over all land and assign, based on personal allegiances of his top knights, a certain acreage or metes and bounds, if you will, or manor in which to adjudicate over, whereby he would then, that one baron, now assigned that manor, would have lords under him, which were also his army and knights, to which those knights in turn would have a structure of people under them, of villaners and serfs and peasants and so forth. The land, being that it was a militant style structure, was an interest that was held as a tenure based on the allegiance, of course, to the king, who held all land as a prerogative of his right to sit upon the throne, and if anything were to be not passed down correctly through the rules of inheritance that evolved through this common law system, or for every other reason, maybe not fulfilling his duties and such, and the promises that were made in order to effect the tenure, then the land would go back to the king and he would deal with it. As in all circumstances in life, man finds some reasons in which to be controlled, and through this structure, he really didn't have any. Especially the lords underneath the barons, who were relegated to do the bidding of the baron, and to some degree had an ear of the king, but mostly as a hierarchical system, first had to bend the ear of the baron. And the lords really didn't have any means in which to carry on their tenure that they were in agreement with. They were structured harshly, or the tenure was structured harshly into how it could be transferred, and at that time it was based on a primogeniture foundation, whereby it had to be passed on to the firstborn son. Man, being man, as I've already mentioned, wanted a means in which to control his interest outside of the common law. This came way through the structure of the Roman Church. The Roman Church was not recognized in common law for the simple fact it was a corporation, and being that the tenure was based on a life, a corporation obviously doesn't represent a life because it exists in perpetuity. So the structure has been set up at the time of these land holdings, whereby the Roman Church can hold a certain proportion of any manor, and it was that portion was not relegated to the incidents and wardships and those kind of things that were owed to the king once the tenure was complete. And generally the tenure was complete either predominantly through the death of that one that was holding the tenure. Now, the church would have a use to the land, and what had transpired through the advance of this use is the lords were circumventing some of the incidents and some of the warships and those sort of things owed to the king by actually assigning more or signing land over to the church, and the church would then either lease it back to them or give it back to that lord, and through the hands of the church, then it wasn't seen in the common law, and thereby the lord was able to circumvent certain portions of his rents and so forth owed to the king for the use of that land. Now, first in the Magna Carta, that stopped. It's called subinfeudation. Wow. For some reason that word is not coming to the tip of my tongue to be able to pronounce it correctly. Subinfeudation. And what that was that, like I just mentioned, the Lord giving a certain portion over the church, and then the church giving it back to the Lord, and in order to circumvent the common law and those incidents owed to the king. So Magna Carta stopped that process, and then in Edward I, at the time of Edward I, which was 1290, was the law of mortmain, whereby now no matter the interest of the Lord wanting to pass over or transfer land over to the church, it had to go through the king's hands first, and then he had to okay it. If it wasn't okayed, then of course the land was not transferred, or that portion was not transferred over to the church. But what stuck was now, well, how do we circumvent the laws of mortmain and those laws that were created in the Magna Carta? And man found other ways. He created joint tenants, where he was able to now give those lands, split the title into joint tenants, thereby if one died, well, then the other one was still alive. Therefore, at the time of his death, again, those incidents and charges and so forth were not owed. And as we learned back at previous video, that the incidents and warships and so forth were owed at the time of death of the one that was holding the tenure. So by transferring into joint tenants, okay, and we've heard this name of fees, no one died, so therefore now that was not allowed, that was not seen in the common law in order for the king, in order to get his due. So throughout this time, the use was now becoming a steadfast feature within the kingdom, where it was not seen in common law, thereby the common law could not interfere, and it was now creating a new system, which is called the use, which didn't really have any regulatory body except for the honor between those the parties that were in agreement to it. And as the case continues, and has been, some agreements had never met fruition. Some of the fees who were in charge of those titles didn't honor the original agreement, and that party, the one who had the right to the use and the beneficiary, had no recourse and no remedy, to which created disturbances within the kingdom. In order to keep peace within the kingdom, then that's where the Lord Chancellor was then given the duty to go into each of these manors and each of these manors' courts and solve the issue based on the agreement that was made. Again, common law couldn't see the agreement, so they then had to create a new court system that was now relegated to just seeing the agreement. And that evolved into equity, or courts of equity, or courts of chancery. And the chancellor was generally the bishop and the right ear of the king and the king's conscience. So that is how we moved from the common law into equity, was generally for man trying to circumvent the common law and finding new ways which he can control a land interest, besides those strict laws of inheritance that evolved through the common law. Now, we then evolved into the Cestui of Richard I, which before Richard became king, he was a feoffee to uses. And he couldn't be a feoffee and be king at the same time, for the reason that the land always cheated back to the king anyway, and therefore it would be a conflict of interest. So he had to create a law that wasn't yet established, which allowed him to then take what he had as a title to give it back to the beneficiary. And thereby, at that very point, the beneficiary held two titles, one to the common law and the legal title, and one to the equitable use. And that then brought us into the Statute of Uses of 1535. And I will stop this recording, and next recording we'll start talking about the Statute of Uses, 1535, and Henry VIII.